Today is the 25th of March 2022 before the Honorable Acting Judge Wilson. We'll call the matter of State versus Tshegofatso, case number SS036 of 2021.
Good morning, Madam. This will let us better sit down and deal with judgment. And I believe Mr. Mokosho has instructed another counsel just to step in to do judgment on behalf.
Yes, thank you, Mr. Mohammed. Is Mr. Shorber in court?
Yes, I am.
There you are, Mr. Shorber. I'm sorry, I couldn't see you with all of these people here. Yes.
Good morning. I'm Tshegofatso from the Johannesburg Bar. I'm standing in for Advocate Makwela this morning. Bishop, I would have mentioned before I'll be informally.
Yes.
And I know that court etiquette at this point doesn't allow for us to introduce ourselves to change.
That's absolutely fine. Thank you very much. In this matter, I make the following order. All previous reporting restrictions imposed by me in relation to these proceedings are now lifted, except for the restriction that requires the media not to broadcast in any way an image of the state prosecutor, whether by film or through his image through the visual media. So all previous reporting restrictions are now lifted, save for the ban on broadcasting or printing or in any other way conveying the state prosecutor's image. In this matter, I've prepared a written judgment, which I shall read out. It will take me about an hour to read the judgment out. Out of respect for this court and for the people involved, I want the judgment listened to in silence. When I read out the verdict, there will be a temptation to react. I understand that temptation. I understand the emotions that whirl around this case. But I would ask everyone in the room, again out of respect for the parties involved and the legal representatives and the court, not to react until the court adjourns. I'm first going to summarize the material evidence led at trial. Then I am going to draw certain conclusions from that evidence. And then I am going to return a verdict. My judgment is as follows. On the 4th of June 2020, Tshegofatso Pule left the Westlake complex in Florida. She had been visiting Tshegofatso, the accused person in this case. She boarded a silver-grey Jeep driven by Muzikaisa Malapani. Mr. Malapani drove her to Noordgesig in Soweto. There he shot her in the chest. He then drove with her to a secluded area in Durban Deep near Rudaport. He tethered her to a tree by her neck. The examination of Ms. Pule conducted post-mortem states that she died of a combination of the gunshot wound and the application of external pressure to her neck. Ms. Pule was at the time carrying Mr. Shorber's baby daughter. She had reached 31 weeks gestation. The fetus was viable, but the baby died from Ms. Pule's wounds. These facts are not disputed. Mr. Malapani has pleaded guilty to Ms. Pule's murder. He is currently serving a 20-year sentence imposed by my brother Mokgotleng J. The question at the center of this case is whether Mr. Malapani killed Ms. Pule at Mr. Shorber's request, and in the expectation that Mr. Shorber would pay him to do so. A further question is whether and to what extent Mr. Shorber assisted Mr. Malapani in murdering Ms. Pule. Mr. Shorber was indicted before me on one count of premeditated murder, with an alternative count of conspiracy to murder and one count of obstruction of justice. He pleaded not guilty to all three counts. The state's case rests principally on Mr. Malapani's account of the contract that he says Mr. Shorber made with him to kill Ms. Pule, and of the steps Mr. Malapani says Mr. Shorber took to implement that contract. The state led Mr. Malapani as its main witness. The state's other evidence was tendered to corroborate Mr. Malapani's version. It is accordingly with an examination of Mr. Malapani's evidence that I must begin. Mr. Malapani said he'd known Mr. Shorba for over 10 years, since they were at school together. Mr. Shorba disputes that he and Mr. Malapani ever attended the same school. It is clear, though, that Mr. Shorba and Mr. Malapani sometimes moved in the same circles, and that they knew each other long before the contract Mr. Malapani alleges came into existence. I am, however, satisfied that they were not close. Both Mr. Shorba and Mr. Malapani agree that neither had the other's telephone number until a few weeks before Miss Pule's death, although they disagree about how they exchanged numbers and, critically, which numbers they exchanged. It is not disputed that Mr. Shorba visited Mr. Malapani in early May 2020. Mr. Malapani alleges that, during their visit, Mr. Shorba told him that he was expecting a child with Miss Pule, but that, if the child was born, this would ruin his relationship with his wife and lose him a great deal of money. If Mr. Shorba did in fact refer to his wife, that was misleading. Mr. Shorba was not married, but he had hopes of marrying Rosetta Moachi and had commenced marriage negotiations with Miss Moachi's family. Mr. Shorba is alleged to have said that Miss Pule did not want to get an abortion and that it was, as a result, necessary to kill her. Mr. Malapani alleges that Mr. Shorba approached him because he understood Mr. Malapani to be connected with the kinds of people who might take on that task. Mr. Malapani said that he initially agreed to find someone else to carry out the murder. At some point, though, he decided to take on the task himself. Mr. Malapani's evidence was equivocal about whether he intended to carry out the murder himself from the outset, but simply let Mr. Shorba think that he was looking for someone else, or whether Mr. Malapani decided to do the job himself sometime after Mr. Shorba's first visit. Mr. Malapani did say that what Mr. Shorba was initially willing to pay for the task, 7,000 rand, later increased to 20,000 rand, was far too little. Mr. Malapani was not consistent in his evidence about where and how the final contract amount was agreed. In his evidence in chief, he suggested that the final figure agreed, some 70,000 rand, was reached during his initial meeting with Mr. Shorba in early May. In cross-examination, however, Mr. Malapani suggested that the 70,000 rand figure was reached in the days and weeks following the initial meeting. In any event, Mr. Malapani said that he held Mr. Shorba off for some time after their initial meeting. Mr. Malapani was vague in his evidence about why. He sought to project the image of a man of affairs who was busy buying and selling cars, and that Mr. Shorba's contract was little more than a distraction to him, something he would get around to when he was ready. Mr. Malapani alleges that there was eventually a subsequent meeting at the Florida Licensing Department. It is not clear whether what Mr. Malapani says was the first attempt on Miss Pule's life was agreed at this meeting, or during one of the telephone calls that Mr. Malapani alleges passed between him and Mr. Shorba. Nonetheless, Mr. Malapani says that the arrangement initially made was that Mr. Malapani would pick Miss Pule up from a bogus job interview that Mr. Shorba would arrange on the 29th of May 2020. The bogus interview would take place at a McDonald's fast food outlet near Gold Reef City. Mr. Malapani said that he was to pick Miss Pule up from the outlet and take her to Mr. Shorba's house. In fairness, it's not really clear from Mr. Malapani's evidence what he thought would happen then. But Mr. Malapani said that Miss Pule was supposed to be killed on that day. Ultimately, though, Mr. Malapani said that Miss Pule never turned up for the interview, and the plan to abduct her from the McDonald's outlet had to be abandoned. Apart from a further occasion on which it is agreed that Mr. Shorba and Mr. Malapani saw each other amongst friends in Dobsonville, the two men did not meet again until the early afternoon of the 4th of June 2020. Mr. Malapani says that Mr. Shorba arrived at Mr. Malapani's house and told him that Mr. Malapani would pick Miss Pule up from Mr. Shorba's home at the Westlake complex and take her to be hanged from the Maritzburg Bridge. Mr. Shorber accepts that he was at Mr. Malapani's house that day, but denies that it was to arrange Miss Pule's murder. Mr. Malapani visited the Moraesburg Bridge, but decided that it was too public a place to stage Miss Pule's hanging. He nonetheless went through with the plan to pick Miss Pule up at Westlake that evening, just after 10 p.m. He says that he arrived at the complex having been drinking consistently throughout the day. He met Miss Pule and Miss Shorber at the gate. He says that Mr. Shorber greeted him and encouraged Miss Pule to get into the jeep. Miss Pule was initially reluctant to do so, but Mr. Malapani told her to be free and assured her that he was there to take her home. Responding to this reassurance and Mr. Shorber's encouragement, Miss Pule got into the jeep and Mr. Malapani drove her away. Mr. Malapani and Mr. Shorber next saw each other on the 6th of June 2020. They met, apparently by chance, at a branch of Cashbuild in Meadowlands. Mr. Malapani alleges that they discussed the payment of the contract amount briefly while standing outside the store. Mr. Shorber is alleged to have reassured Mr. Malapani that he was getting the money together and would pay Mr. Malapani soon. Mr. Malapani was arrested on suspicion of Miss Pule's murder just over a week later, on the 15th of June 2020. There is no evidence before me, and Mr. Malapani did not suggest, that Mr. Shorber ultimately paid Mr. Malapani anything at all for the murder of Miss Pule. Mr. Makabela, who appeared for Mr. Shorber before me, cross-examined Mr. Malapani extensively. His cross-examination consisted of 4 main lines of attack on Mr. Malapani's evidence. First, Mr. Makabela produced evidence that Mr. Malapani had threatened Mr. Shorber. Mr. Malapani had promised to arrange Mr. Shorber's assault in prison. He had also made a statement to the media to the effect that he hoped that Miss Pule's family get to Mr. Shorber before he does. Mr. Malapani admitted the threats. He did not suggest that he did not mean them. The gist of Mr. Malapani's evidence was, in fact, that he would put Mr. Shorber in hospital if the opportunity presented itself. Second, Mr. Makabela put to Mr. Malapani that the story he had told in court was wildly at odds with the confession statement he first gave to the police. This fact had been canvassed by Mr. Muhammad, who appeared for the state, in Mr. Malapani's evidence in chief. But Mr. Makabela covered the ground again in much more detail. In his confession statement, Mr. Malapani put Mr. Shorber at the scene of Miss Pule's murder. He made out that Mr. Shorber had stabbed Miss Pule, had placed the ligature around Miss Pule's neck, and had hauled Miss Pule off the ground. None of this is true. Mr. Malapani acknowledged that his confession statement to the police was dishonest. He explained that dishonesty by reference to his desire to tie Mr. Shorber more closely to Miss Pule's murder. He wanted to punish Mr. Shorber for leading the police to CCTV footage of the jeep used to pick Miss Pule up at Westlake. He also suggested that he was racked with guilt for what he had done. This is something to which I give some credence, given that Mr. Malapani broke down at least once during his evidence. Nevertheless, it has to be accepted, and Mr. Malapani did accept, that he is not only a murderer, but a proven liar. Nobody suggests that Mr. Shorber was ever at the scene of Miss Pule's death, or that Miss Pule was stabbed, or that Mr. Shorber inflicted any of her wounds directly. The proposition that Miss Pule was stabbed is also wholly inconsistent with the results of the post-mortem examination placed before me. Mr. Makabela's third line of cross-examination sought to establish areas of vagueness and inconsistency in Mr. Malapani's evidence. I have already adverted to some of these, but Mr. Makabela pressed the point further. Mr. Makabela challenged almost every aspect of Mr. Malapani's account of his movements on the afternoon and evening of the 4th of June 2020. For example, it was put to Mr. Malapani that he could not, as he had suggested, have dropped his cousin Sirpo off at a taxi stop before proceeding to the Westlake complex, because no taxis were allowed to run on the 4th of June 2020. Mr. Malapani said that there were, as a fact, taxis operating that day, whatever the regulations said. Mr. Macabela also challenged Mr. Malapani to account for the hours that cell phone records show that he drove around the Florida area after he picked Miss Pule up and shot her. Mr. Malapani couldn't really do this, except to say that he was drunk and in shock at what he'd done. Mr. Macabela also challenged Mr. Malapani's motive for incriminating Mr. Shorba. Mr. Malapani had said that he had decided to tell the police that Mr. Shorba directly inflicted the injuries that led to Miss Pule's death, because Mr. Shorba had led the police to CCTV footage of Mr. Malapani arriving at the Westlake complex. However, on Mr. Malapani's own version, Mr. Shorba had assured him that the CCTV cameras at the Westlake complex were positioned so as not to be able to read number plates of cars pulling up outside. CCTV evidence later presented to me demonstrated that this is not strictly true. There is, in fact, a camera angle that might reveal a number plate. It was nonetheless put to Mr. Malapani that he could not have been unduly surprised or worried when he found out that Mr. Shorba had led the police to the CCTV footage. Finally, Mr. Macabela put Mr. Shorba's version to Mr. Malapani. The core of that version was that Mr. Malapani was a small-time gangster. He had a sideline in illegally selling cigarettes during the ban on their trade in terms of the regulations made under the Disaster Management Act 53 of 2005, which lasted for much of 2020. Mr. Shorba was a smoker in need of a supply of cigarettes and arranged to buy them from Mr. Malapani. This, Mr. Macabela put to Mr. Malapani, explains all of their contact, including Mr. Shorba's visits to Mr. Malapani's home. Mr. Shorba's version was that this arrangement sprung from a chance meeting on Main Reef Road. Calling from one car to another while stationary at a robot, Mr. Shorba alleged that Mr. Malapani offered to sell cigarettes to Mr. Shorba. Mr. Shorba said that the men agreed that he would obtain Mr. Malapani's number from a mutual friend who was also Mr. Malapani's neighbour, and then contact Mr. Malapani to arrange the transaction. Mr. Malapani denied that this conversation ever took place. He also denied that he illegally sold cigarettes. He readily accepted, though, that he lived what he himself called a gangster life, which included the sale of alcohol in breach of the disaster management regulations. Muzi Kumalo, a friend of Mr. Malapani who gave evidence for the state, also suggested that the cars Mr. Malapani dealt in were stolen. Mr. Macabela's cross-examination was clearly directed at painting Mr. Malapani as a liar with an agenda to implicate Mr. Shorba in Miss Pule's death, come what may. In argument, he characterized Mr. Malapani as something of a fantasist, a storyteller, who had spun an incredible tale about Mr. Shorba's involvement in a crime he had in fact committed on his own. It was principally on that basis that Mr. Macabela applied, at the close of the state's case, for Mr. Shorba's discharge under Section 174 of the Criminal Procedure Act 51 of 1977. I refused that application and undertook to give my reasons in this judgment. These, briefly, are my reasons. Mr. Malapani's evidence was not so unsatisfactory that it could be rejected in its entirety, which is what Mr. Macabela urged me to do. A court will seldom disregard a witness's evidence merely because it contains some untruths, or even because the witness dislikes the person against whom the evidence is tendered. Even a serial liar sometimes tells the truth. Even a witness with an axe to grind may give evidence that is clear and honest against the object of their animus. It is necessary in these situations to carefully evaluate the evidence given and to consider whether it is so tainted by bias, inconsistency, or improbability that none of it can safely be accepted. Mr. Malapani's evidence was not of that nature. It is true that, by the time Mr. Makabela's cross-examination had concluded, Mr. Malapani's evidence was far from untarnished. However, at its core, it contained a number of unchallenged assertions that required an explanation from Mr. Shorba. First, there was the undisputed fact that there had been at least 2 meetings between Mr. Shorba and the man everyone accepts killed Miss Pule. Second, there was Mr. Malapani's unchallenged assertion that he had no prior relationship with Miss Pule, and that he in fact did not know her, and had no motive for or means of making contact with her, other than with Mr. Shorba's assistance and at Mr. Shorba's behest. Third, there was Mr. Malapani's unchallenged evidence that he had picked Miss Pule up from Mr. Shorba's complex on the night that he killed her, and that Mr. Shorba was present when he did so. These aspects of the evidence were enough in themselves to put Mr. Shorba on his defence. He would, at the very least, have to confirm that his contact with Mr. Malapani was intended to procure cigarettes and not to arrange Miss Pule's murder. That said, Mr. Malapani's evidence must clearly be treated with caution. He is the single witness to most of the events he narrated. He is, on his own version, an accomplice, a liar, and someone with an axe to grind against Mr. Shorba, although he says that his animus against Mr. Shorba arises from Mr. Shorba's participation in Miss Pule's murder. Despite these obvious notes of caution, there was, for the reasons I have given, clearly material in Mr. Malapani's evidence on which a reasonable court acting carefully might convict Mr. Shorba. That is why I refuse the discharge application. In any event, the state's case did not begin and end with Mr. Malapani's testimony. Mr. Muhammad also placed material before me that tended to corroborate Mr. Malapani's version. It is to that evidence that I now turn. The state's first witness, Tshegofatso Sita, confirmed that Miss Pule was invited to an interview at a McDonald's in Ormond, which is near Gold Reef City. The invitation was sent by SMS to Miss Pule. It purported to be from a woman called Zanele or Zandile, Miss Sita couldn't remember which, who said she acted on behalf of Kelly Recruitment. Miss Sita saw the SMS messages. On the 29th of May 2020, Miss Sita saw further SMS messages from Zanele or Zandile, which told Miss Pule that she should go to the McDonald's in Ormond, where a jeep would be waiting to pick her up. Miss Sita confirms that Miss Pule did not go in the end, and that, it seems to me, is entirely consistent with Mr. Malapani's account of the 29th of May 2020. Miss Sita's evidence was essentially unchallenged in cross-examination. Mr. Makabela pointed out that the details of the McDonald's interview had been trailed in the media before the trial, but he did not challenge Miss Sita's version that she saw the SMS messages that attempted to arrange it, nor did he suggest that Miss Sita was mistaken or dishonest about them. Mr. Malapani says that he communicated with Mr. Shorba using a cell phone number that turned out to be different from the number registered to Mr. Shorba. It was alleged that Mr. Shorba asked Mr. Malapani to use a particular 081 number. Before me, Mr. Shorba denied any knowledge of this number or any connection with it. Mr. Shorba's ordinary registered cell phone number is an 076 number. The state's theory is that Mr. Malapani and Mr. Shorba would communicate about the planning of Miss Pule's murder on the 081 number, so as to avoid having to explain frequent communication between the two men on Mr. Shorba's 076 number. To link Mr. Shorba to the 081 number, the state led extensive and undisputed evidence of cell site analyses, which tended to show multiple occasions on which the 081 number and Mr. Shorber's 076 number were used at roughly the same place at about the same time. The cell phone records placed before me were voluminous, but Mr. Makabela and Mr. Muhammad distilled them to an agreed exhibit marked T, which contained the cell site evidence that was put to Mr. Shorber in cross-examination. By agreeing that the evidence was put, Mr. Makabela was of course not agreeing that it incriminated Mr. Shorber. Nor was Mr. Muhammad agreeing that the evidence put to Mr. Shorber was the only cell site evidence that the state regarded as incriminating. Exhibit T constitutes nothing more than an agreed summary of the information relied on by the state during its cross-examination of Mr. Shorber. Exhibit T summarizes 7 separate occasions between the 20th of May and the 5th of June 2020, on which both Mr. Shorber's 076 number and the 081 number routed communication through identical or neighboring cell phone towers within a few minutes of each other. On 3 occasions, it was shown that the 076 number had made a call to Ms. Pule's phone within minutes of the 081 number calling Mr. Malapani's phone. On each of the other 4 occasions, it was shown that the 081 number had called Mr. Malapani's phone at around the same time and in the same area that Mr. Shorber's 076 number had been used to make a call. Now, it's important to be clear about the limits of the cell site evidence. It did not pinpoint the location of the 081 and 076 handsets. It merely showed that they had been activated within the range of a particular cell phone tower at a particular time. Where they were routed at the same time through the same cell phone tower, the handsets could have been in the possession of the same person. But they could just as easily have been at the opposite ends of the coverage area of the relevant tower, each in the possession of a person with no knowledge of the other's existence. The cell phone towers in question were Florida Park, the Florida Samlin Tower, the Durban Deep Tower, and the Cresta Tower. Each had a coverage area of between 1.4 and 2.7 square kilometers. Obviously, one instance of the 076 and 081 numbers being used in the range of the same tower at about the same time would have meant nothing. Even the repeated use of the 2 numbers in the same area at the same time would not demonstrate much on its own. However, the corroborative value of the cell site evidence increases when regard is had to the 3 occasions on which the 081 number was used to call Mr. Malapani shortly before or after the 076 number called Ms. Pule. The fact that on the 7 separate occasions on which one or other phone was used, at least one of them was being used to communicate with either Ms. Pule or Mr. Malapani. The fact that all 7 occasions were over the relatively compressed period between the 20th of May and the 6th of June 2020. And finally, the fact that on one occasion, the evidence puts both the 081 number and the 076 number in Cresta at around the time Mr. Shorber accepts that he was at the Cresta Mall on the 30th of May 2020. Again, I caution that the cell site evidence could never be enough on its own to incriminate Mr. Shorber, much less to convict him. However, I accept that it is weighty enough to provide some corroboration to Mr. Malapani's assertion that Mr. Shorber used the 081 number to communicate with him. The third main source of corroboration for Mr. Malapani's version is the CCTV footage of the entrance to the Westlake complex on the evening of the 4th of June 2020. What that evidence showed was the subject of fairly extensive debate. The parties were initially content to place the material before me in the form of a memory stick containing the footage, which I was invited to watch at my leisure. the state extracted a series of still images from that footage, which were used in evidence and marked as Exhibit H. There was never any dispute that the footage showed Mr. Shorber and Ms. Pule walking out of the main gate of the complex at around 22:06 on the 4th of June 2020. A silver grey Jeep had just pulled up outside. But then the footage skips 3 minutes to around 22:09, at which point the Jeep is pulling away and Mr. Shorber is walking back through the gate. Brian Watson, who is a trustee of the Westlake Complex Body Corporate and who has had 16 years' experience of operating the CCTV equipment at the complex, gave evidence for the state. He explained that the reason why the CCTV footage skipped for 3 minutes between about 22:06 and 22:09 was that the recording mechanism on the camera is activated only by the movement of the gate itself, or any motion between the camera and the gate. Accordingly, the CCTV camera would stop recording if the only motion within its field was on the other side of the gate. Mr. Watson also explained that, because of the access control restrictions put in place in response to the COVID-19 national state of disaster, the main gate was, in fact, the only means of entry to and egress from the complex at the time. The natural inference to be drawn from all of this is that the Jeep, Ms. Pule and Mr. Shorber were outside the main gate of the complex for approximately 3 minutes. But Mr. Shorber vehemently denied in his evidence that this could have been so. In closing argument, I put to Mr. Makabela that the CCTV footage, the accuracy of which was not placed in dispute, was conclusive in this respect. Whatever the passage of time felt like to Mr. Shorber, it must have been around 3 minutes. That inference was accepted at the time, and I reserved judgment on the basis that it was uncontested. Shortly after I reserved judgment, however, Mr. Shorber indicated that he wanted to reopen his case in order for me to view the CCTV footage in open court and to hear argument on what inferences could be drawn from it. That application was made on the 4th of March 2022. The state did not oppose it. I granted the application. The party's representatives and I viewed the material in court on that day. The critical parts of the footage were viewed at least twice. At the end of the exercise, it was accepted that the only inference to be drawn from the CCTV footage was that Ms. Pule and Mr. Shorber were in fact outside the gate and next to the Jeep for just under 3 minutes. This, again, is corroborative of Mr. Malapani's version that he picked up Ms. Pule at around 2200 in a Jeep. The time Mr. Shorber spent outside the gate was sufficient for there to have been a short conversation between Mr. Malapani, Mr. Shorber and Ms. Pule of the nature Mr. Malapani alleged. Finally, the state placed reliance on a record of cell phone communication between the 081 number and Mr. Malapani on the afternoon and evening of the 4th of June 2020, which formed part of Exhibit I-2 before me. The heaviest reliance was placed on a 13-second voice call from the 081 number to Mr. Malapani, just minutes before Mr. Malapani said he drew up at the Westlake Gate. The CCTV footage showed Ms. Pule and Mr. Shorber walking up to the complex gate at 2200, before going back into the complex at 2201. The call from the 081 number to Mr. Malapani was placed at 2204. It was routed through the Florida Park cell phone tower, which covers the Westlake complex. The CCTV footage shows Mr. Shorber and Ms. Pule coming back outside at 2206. This was, Mr. Muhammad urged, consistent with Mr. Shorber discovering that Mr. Malapani was not outside at 2200 as agreed, and using the 081 number to hurry Mr. Malapani along to pick Ms. Pule up. I have already found that despite its imperfections, Mr. Malapani's evidence would have been enough to put Mr. Shorber on his defence. But when read with the corroborating evidence I've set out above, the core of Mr. Malapani's evidence takes on a reliable character. By the time the state closed its case, Mr. Shorba had a lot to explain. Mr. Shorba was the first witness called for the defence. Much of his evidence was taken up with a description of his relationship with Ms. Pule, an account of his interactions with Mr. Malapani, both before and after the 4th of June 2020, and an account of what happened on the evening of the 4th of June itself. Mr. Shorba had been in a long-term relationship with Ms. Moachi for around 13 years before Ms. Pule's death. They had taken out a joint bond on a property in 2015, and he had initiated premarital negotiations with Ms. Moachi's family at some point thereafter. The relationship ended in early 2020, shortly after Ms. Moachi's mother died of cancer. It was clear from his evidence, however, that Mr. Shorba hoped for and expected a reconciliation. Mr. Shorba emphasised that Ms. Moachi had remained supportive of him throughout these proceedings. Mr. Shorba met Ms. Pule in 2018. Despite being at the time in what he presented as a committed relationship with Ms. Moachi, it is clear that he then began a parallel relationship with Ms. Pule. Mr. Shorba said that Ms. Pule understood and was happy with the nature of their relationship, that she knew about Ms. Moachi, and that she understood that his relationship with her was no more than casual. In early 2019, Ms. Pule fell pregnant, but that pregnancy was terminated, apparently by mutual agreement between Ms. Pule and Mr. Shorba. Later, in 2019, Ms. Pule fell pregnant again, but she did not tell Mr. Shorba about the pregnancy until the 28th of January 2020. By that time, Ms. Pule must have been around 11 or 12 weeks pregnant. It is not clear to me whether she would have been able to arrange a termination at will at that stage. But Mr. Shorba was emphatic that Ms. Pule did not want one and that he respected that decision. Mr. Shorba narrated much of the last few months of his relationship with Ms. Pule by reading out extracts from their WhatsApp conversations, which were placed before me as Exhibit D. The bulk of that exchange spanned the period from 28 January to 4 June 2020. It started with Ms. Pule telling Mr. Shorba about the pregnancy, and it ended with Ms. Pule arriving at the Westlake complex on the 4th of June 2020. Mr. Makabela sought to present the conversations as evidence of an ordinary relationship that had its ups and downs. He urged an interpretation of the messages that would create at least some reasonable doubt about whether Mr. Shorba could in fact kill Ms. Pule and his unborn child. I am willing to accept that the WhatsApps do not incriminate Mr. Shorba directly, but they do not convince me that he was particularly enthusiastic about the pregnancy. Mr. Shorba accepted Ms. Pule's decision to have an abortion. Mr. Shorba accepted Ms. Pule's decision not to have an abortion. He attended doctor's appointments with Ms. Pule. He arranged with her to buy baby clothes. He sent her money. He frequently ordered her Ubers. But he did much of this only after putting Ms. Pule off or failing to respond promptly to her messages. These exchanges are underpinned by what comes across as Mr. Shorba's emotional unavailability and Ms. Pule's periodic expression of deep distrust in Mr. Shorba and his sporadic attempts to reassure her that he was genuinely interested in her and the child. Ms. Pule was obviously hopeful of some sort of future with Mr. Shorba and perhaps even life as a family. But Mr. Shorba was very clearly not open to this. He did, though, continue to have sex with Ms. Pule from time to time. In sum, the WhatsApp exchange neither inculpates nor exculpates Mr. Shorba, but it confirms a range of important background facts: that Mr. Shorba and Ms. Pule were having a relationship, that the relationship had resulted in Ms. Pule's pregnancy, that Ms. Pule did not want to terminate the pregnancy and Mr. Shorba agreed to that Mr. Shorba learned of the pregnancy late in January 2020, that he sometimes gave Ms. Pule money, and that arrangements were made for Ms. Pule to go with Mr. Shorba to Cresta Mall to buy baby clothes on the 30th of May 2020, and that Ms. Pule was with Mr. Shoba on the 4th of June 2020. It also gives an impression of the tenor of the relationship, but the exchange cannot be pushed much further than that. Mr. Shoba accepted that he knew Mr. Malapani and had known him for over a decade. They were not close. Mr. Shoba sometimes visited a friend who lived across the street from Mr. Malapani, but their acquaintance was casual. Mr. Shoba says that his closer engagement with Mr. Malapani began at some point during what has become known as the hard lockdown during March and April 2020. Mr. Shoba and Mr. Malapani met at an intersection on Main Reef Road. They were stopped at a robot in their cars alongside each other. Mr. Shoba spoke to Mr. Malapani through his passenger side window. The men exchanged pleasantries. Mr. Malapani told Mr. Shoba that he had cigarettes to sell and that he could supply them in bulk. Mr. Shoba was attracted by that idea and said that he would get Mr. Malapani's contact details from their mutual friend who lived across the road from Mr. Malapani. The exchange ended there. Mr. Shoba admits visiting Mr. Malapani on 3 or 4 occasions, and he accepts that 2 of these occasions were sometime in early May 2020 and again on the 4th of June 2020. However, Mr. Shoba says that these engagements were strictly limited to the purchase of cigarettes. Any telephone calls to Mr. Malapani from Mr. Shoba's 081 number at around that time were also about nothing more than the purchase of cigarettes. Mr. Shoba denied, as I have said, that he ever used or had access to the 081 number. The only other time Mr. Shoba accepts that he was in Mr. Malapani's presence was when he saw Mr. Malapani at Cash Build on the 6th of June 2020. There, his exchanges with Mr. Malapani were limited to greetings as he entered the store. Mr. Malapani did not have a mask and so could not go inside. Mr. Shoba denies that they discussed anything of substance on that day, let alone that he promised to compensate Mr. Malapani for killing Miss Pule. Mr. Malapani, for his part, denies running into Mr. Shoba on Main Reef Road. He also denies selling Mr. Shoba cigarettes. In this second denial, Mr. Malapani's evidence is corroborated by Mr. Kamalo, who gave evidence for the state, and by Mr. Malapani's former partner, who was called by the defence after the state released her as a witness. Both said that Mr. Malapani was not selling cigarettes during the tobacco ban. In response to a question from me, Mr. Malapani's former partner said that she would have known if Mr. Malapani was selling cigarettes from the house they shared. She also said that Mr. Malapani was not particularly secretive about how he made his money. This brings me to Mr. Shoba's account of the events of 4th of June 2020 itself. Mr. Shoba alleged that, having purchased cigarettes from Mr. Malapani earlier in the day, he received Miss Pule at his Westlake home at around 6 p.m. Mr. Shoba said that the purpose of the visit was to make a list of baby clothes that they had been unable to get from Cresta the weekend before. Miss Pule had a telephone conversation with a friend via a WhatsApp voice call, using Mr. Shoba's Wi-Fi connection. Mr. Shoba heard the conversation because it was conducted on Miss Pule's phone speaker. Miss Pule's friend, Miss Senakwani, confirmed this conversation in her evidence for the state. That conversation was also apparently about baby clothes. Mr. Shoba says that Miss Pule was on her phone using his Wi-Fi connection for much of that visit. She was texting, but did not make or receive any voice calls, other than the call with Miss Senakwani. They watched TV together and had takeaway food. Mr. Shoba received a call from Miss Moachi, after which he says Miss Pule became sulky. Later, Miss Pule announced that her ride was outside and asked to be let out. Mr. Shoba escorted Miss Pule outside. He said that she spoke to the driver. He says that the driver was wearing a cap and a mask, and that he did not recognize the driver or the car. He says he was standing around 7 or 8 meters from the Jeep, but that he heard the conversation between the driver and Miss Pule. He heard Miss Pule say to the driver, "You're sloshed." Both Mr. Makabela and Mr. Mohammed asked Mr. Shoba whether he was concerned about letting Miss Pule get into a strange car with a man he did not recognize. Mr. Shoba answered that he was not particularly concerned because Miss Pule seemed to know the driver. Ms. Shoba says that this was the last contact he had with Miss Pule. I have now set out the material evidence led at Mr. Shoba's trial. It is, of course, not a chronicle of the trial, but it constitutes the evidence that is directly relevant to assessing whether the state has met its burden in this case. I now turn to consider whether the state has discharged that burden. To convict Mr. Shoba of murder, I must be satisfied, beyond reasonable doubt, that he made an agreement with Mr. Malapani, that Mr. Malapani would kill Miss Pule, and that Mr. Shoba took steps to aid Mr. Malapani in doing so. A mere agreement to kill would result only in a conviction for conspiracy to murder. To be guilty of murder, Mr. Shoba must also have assisted Mr. Malapani in implementing that agreement. The relevant cases have a great deal to say about what it means to be sure of something beyond reasonable doubt. Nothing I could say here would add anything to the way the test has been explained in the past. The simplest way to conceive of the test is, in my view, to ask first what facts I can be sure are true, and then second, to decide whether there is any reasonably possible account of those facts, however unlikely, that is consistent with Mr. Shoba's innocence. It does not matter whether I subjectively believe that Mr. Shoba is guilty, nor does it matter if I subjectively disbelieve parts or the whole of his story. What matters is whether, objectively evaluated, the facts proved before me are consistent with the reasonable possibility that he is innocent. If they are, then I must acquit him. The mirror image of that test is that the state must have established that Mr. Shoba's knowing and intentional participation in the murder is the only reasonable conclusion to be drawn from the proven facts. On evaluating the material evidence as a whole, it seems to me that there is no account of the facts proven before me that is consistent with Mr. Shoba's innocence. In the first place, Mr. Shoba's explanation for his dealings with Mr. Malapani may safely be rejected as false. It is denied by two witnesses whose credibility and reliability have never been challenged, and by Mr. Malapani himself. I do not accept that Mr. Shoba's visits and telephone calls to Mr. Malapani were about the purchase of cigarettes, because I do not accept that Mr. Malapani ever sold them. That begs the question of what Mr. Shoba's visits were really about. Once I have rejected Mr. Shoba's evidence that they were about cigarettes, there is no evidence before me that they were about anything other than arranging Miss Pule's death. As I have already pointed out, the core of Mr. Malapani's evidence in this respect was virtually untouched by Mr. Makabela. Mr. Malapani did not know Miss Pule. He had no obvious motive or opportunity to kill her other than those Mr. Shoba gave him. Mr. Shoba accepted under cross-examination that the state had investigated the possibility of another connection between Miss Pule and Mr. Malapani, and had turned up no evidence that there was any such connection. Moreover, having treated Mr. Malapani's evidence with the requisite caution, I see no alternative but to accept that the material core of Mr. Malapani's evidence is clear and satisfactory in every material respect. I have already given my reasons for reaching that conclusion. I have also sought and established critical respects in which Mr. Malapani's evidence is corroborated. The most important corroboration comes from what happened outside the Westlake complex on the evening of the 4th of June 2020. Mr. Shorba says that Ms. Pule initiated her departure by saying that her ride was waiting outside. But of course it was not waiting outside. CCTV footage showed that Mr. Shorba and Ms. Pule went outside at 10 o'clock, and no one was there. A call was then placed to Mr. Malapani from the 081 number and routed through the cell phone tower that covers the Westlake complex. Mr. Shorba and Ms. Pule then returned to the gate as Mr. Malapani arrived. Although there was some debate towards the end of the trial about whether Mr. Shorba had conceded that Mr. Malapani was driving the Jeep that picked Ms. Pule up on the 4th of June 2020, it cannot seriously be suggested on the evidence that it was anyone other than Mr. Malapani. That being so, I find it impossible to conceive that Mr. Shorba did not instantly recognize him. Although I must accept Mr. Shorba's version that Mr. Malapani was wearing a cap and a mask, Mr. Shorba says that he heard a conversation between Mr. Malapani and Ms. Pule. He must at least have recognized Mr. Malapani's voice. On his own version, he had spoken to Mr. Malapani on several occasions before. On the first recent occasion, Mr. Shorba says they spoke. They were calling from car to car on Main Reef Road. Despite seeking to create the impression of a concerned and expectant father, Mr. Shorba does not appear to have been worried that Ms. Pule was getting into a car late at night with a man who she had herself pointed out was drunk. Mr. Shorba accepted that the Jeep did not look like an Uber and probably wasn't an Uber. He says he was not concerned because Ms. Pule appeared to know Mr. Malapani, but that is plainly insufficient. I am driven to conclude that had he genuinely not known who was driving the car, Mr. Shorba would have shown at least some interest in the identity of the man who had arrived, drunk, to pick up the mother of his unborn child. The only reasonable explanation for Mr. Shorba's apparent lack of interest is that he knew exactly who had come and what was going to happen to Ms. Pule when she drove off with him. He had in fact arranged with Mr. Malapani to collect and then kill Ms. Pule. Ms. Pule did not say that her ride was waiting outside. Mr. Shorba told her that he, as was normal, had arranged a lift for her. They went outside to find that there was no one waiting. Mr. Shorba then called Mr. Malapani from his 081 number to hurry him up. Mr. Malapani arrived a short time later. Accordingly, I reject Mr. Shorba's version of what happened when Ms. Pule left the Westlake complex on the 4th of June 2020. It is not reasonably possibly true. By contrast, to reject the state's case, I would have to find that Mr. Malapani had lied about virtually everything he'd said, but had nonetheless been fortuitously assisted in his lies by 4 extraordinary pieces of luck. These are the fact that the phone Mr. Malapani says Mr. Shorba used to contact him to arrange the murder turned up in the same area at about the same time as Mr. Shorba's registered phone, on no less than 7 occasions in the 2 weeks before Ms. Pule was killed. That the 081 number placed a call to Mr. Malapani in the minutes before Mr. Shorba and Ms. Pule's first and second trip to the complex gate. That Mr. Shorba would be remarkably uncurious about Mr. Malapani's picking up Ms. Pule from his residence at Westlake. And that Mr. Malapani's real motive for the murder and the nature of his relationship with Ms. Pule, whatever they were, would remain undetected. I would also have to accept that Mr. Malapani was prepared to commit a gruesome murder for no detectable motive, and to concoct a story that implicated Mr. Shorba, again, without any apparent pre-existing animus towards Mr. Shorba that would motivate him to do so. I would finally have to accept that both Mr. Khumalo and Mr. Malapani's former partner are lying or mistaken when they say that Mr. Malapani did not sell cigarettes during the ban on tobacco sales. There are simply no facts before me that would support any of these conclusions. but the facts that have been proved all point in one direction: that Mr. Shoba arranged for Mr. Malapane to kill Ms. Pule, that he first attempted to do so by having Mr. Malapane meet Ms. Pule at the Ormond McDonald's outlet, and that when that plan failed, he knowingly and intentionally delivered Ms. Pule into Mr. Malapane's hands on the night of the 4th of June 2020. It remains to deal with the third count on the indictment, that of obstructing justice. It seems to me that the state has not been entirely consistent in its approach to this charge. The evidence it initially led appeared to be setting up a case that Mr. Shoba had tampered with the cell phone he had handed over to the police when they were investigating Ms. Pule's disappearance. It was said that there were incriminating WhatsApps deleted from that phone. However, these incriminating WhatsApps were never produced, nor was it proved how Mr. Shoba had tampered with the phone or deleted them. Recognizing that this was likely fatal to the state's case on the obstruction charge, Mr. Mohammed changed tack. He argued that Mr. Shoba had obstructed justice when he gave a false version to the police about Ms. Pule's disappearance. It is in principle possible for a person to obstruct justice by giving a false statement to the police with the intention of exculpating themselves from an offence they know they have committed. However, in my view, much will depend on the nature of the statement and the extent to which the statement was intended to, or necessitated by the need to, avoid self-incrimination, the privilege against which is enshrined in Section 35(3)J of the Constitution, 1996. The difficult question, it seems to me, is whether the false statement forming the basis of the charge was the only realistic alternative to an act of self-incrimination. I would have a great deal of difficulty in convicting a person who had lied to the police solely to avoid incriminating themselves. But it is in any event far from clear where the line between obstruction of justice and justified avoidance of self-incrimination is to be drawn. Very little argument was addressed to me on this issue. More fundamentally, though, Mr. Shoba was not given an opportunity to comment in cross-examination on the specific statements that the state alleges are false, nor was it put to Mr. Shoba that he had concocted a story with the intent to obstruct the investigation into Ms. Pule's death. There is accordingly no basis on which I can convict Mr. Shoba on the obstruction charge. Mr. Shoba, can you stand up, please? For these reasons, Mr. Shoba, I've reached the following verdicts. On count 1 of the indictment, I found you guilty of the premeditated murder of Tshegofatso Pule. On count 2 of the indictment, I find you not guilty of obstructing justice. You may sit down. I hand down the judgment. Copies of the judgment will be made available first to the party's legal representatives and then to any other interested person. I've asked the High Court Library to ensure that the South African Legal Information Institute publishes the judgment online as soon as possible. Mr. Mohammed, when is it appropriate to move to a sentencing hearing?
Yes. Lord, before I make submissions regarding the sentence, my learned friend would like to address the Honourable Court on a suitable date first.
Yes.
With respect to further hearing on sentencing, my instruction, of course, to request a further remand for those purposes.
Yes. Granted. Yes. When do you want to remand to?
Lord, we haven't necessarily come to a date with my learned friend. However, Mr. Makwele has informed that he's available anytime after the 9th of May.
9th of May.
We need to allow for a period of at least around 6 weeks for the preparation of the reports.
Very well. Mr. Mohammed, what day is the 9th of May?
The 9th of May is a Monday. It's Monday. I have no objection if it be postponed to the 10th of May.
10th of May.
If this Honourable Court is still available on a criminal bench during next term.
Well, I'll have to be. Yes. The 10th of May?
It will suit us, madam.
Yes. So we'll postpone to the 10th of May. Mr. Shoba, can you stand up again, please? Mr. Shoba, Given that the verdict I've reached on the primary count on the indictment, it's now necessary for me to hear evidence and argument relating to the appropriate sentence. I will hear that evidence and argument on the 10th of May, 2022. I will postpone this matter until then, and you'll obviously remain in custody until then. You can sit down. Is there anything else, Mr. Mohammed?
That concludes our own.
Yes, thank you all for your assistance. The court adjourns.
All right.